So when looking at Australian sovereignty, it's important to start with the underlying proposition that we accept, as at the year 1788, that the British system, the UK Parliament, and all of the rules of the common law were already in existence. They were valid, they were legitimately exercised, and the authority was recognised of that system. So it would be helpful to know then, in the early 1700s, that the process of what they call commuting of death sentences in the UK could be used as a substitute for the death penalty. In other words, somebody who'd committed an offence that was punishable with death in the United Kingdom, and to be honest, the bar that was set in terms of things you could get a death penalty for was a lot lower than it was in subsequent centuries. But part of commuting the sentence is that instead of getting the death penalty, you get sent out to the colonies. Now, originally when this legislation was passed by the UK Parliament, they meant the colonies of North America. So people were put in transportation vessels from 1717 onwards and sent to the New World to start a new life. Of course, after the Americans declared independence in 1776, this posed something of a problem for the British Parliament. And so, fortunately, a few years earlier, Captain Cook had made some maps and charts of the eastern coast of Australia. And so the new colony of New South Wales, Norfolk Island and Bermuda were selected as destinations in which these commuted sentences, death sentences, could be used to send large numbers of people and prisoners. And so this process, it actually continued for a very long time. The process of commuting sentences and transporting people to Australia continued all the way up until the late 1800s. So this process of transportation and the creation of these new colonies in New South Wales and Van Diemen's Land, subsequently called Tasmania, was something of a problem in terms of the underlying laws and legal system. You see, as we referred earlier to the Treaty of Westphalia, the idea of this Westphalian model of sovereignty, whereby there are three new ways of acquiring territory, by conquest, by sort of treaty or secession, or by settlement of a land that belongs to no one. These have different mechanisms in terms of how the underlying law and legal system is supposed to operate, at least from the time that particular territory is acquired. See, if there was conquest, by convention, the victorious party leaves the existing legal regime in place, or at least doesn't create sweeping changes overnight. If there is some sort of secession or treaty, then the arrangement is done, I guess, as part of the treaty. Which laws are we going to keep and which ones are we not going to keep? How is this going to operate? And almost like analogous to how we would enshrine things in contract. And the third one, settlement, is the idea that, well, hey, if the land doesn't belong to anyone, then our existing laws apply in the place. Now, the English jurist William Blackstone wrote in the 1700s that the common law of England ought, very much this phrase in this normative philosophical mindset, the laws of England, or Britain at that stage, ought to become a part of the law of that new territory. In this concept is known as the reception of law. You receive the law at the point of settlement. But an important point to note there, which was very core to what William Blackstone was saying, that you only take the laws from your mother country, from the original land, as you need to apply to the unique situation. In other words, you take the laws of your homeland, but you have to adapt them and change them to the peculiar circumstances of the particular land that these laws now operate in. In the new colonies, in the early days, there was unfortunately some aspects of confusion as to what there was. So the imperial parliament, so essentially the UK Parliament, making laws for all of the British Empire, passed the Australian Courts Act, which essentially mapped out what most people sort of appreciated to be the case, that British law had been received, and they specified a particular date and said, look, British law has been received into the new colonies as at the 25th of July 1828. And so that's known as the date of reception of English law, and applied to the colonies of New South Wales and Van Diemen's Land, now Tasmania. And just note that this date of reception is the same for Victoria and Queensland, because they were essentially carved out, chopped off the colony of New South Wales. But the date of reception for the other states, for South Australia and Western Australia, are different. And so I've talked earlier about this idea of legitimacy and authority, and it's important to note this particular date, this particular point in time, because really when we're looking at the development of the Australian legal system, it really only can operate independently from that particular point in time. And the common law was developed, and the various parliaments later would pass laws specifically for and to do with the colonies of Australia. It's really a very, very small step, much as the other steps of the various sort of sovereignty documents that we talked about, the Bill of Rights, the Magna Carta, and so on. And it's something that leads towards Australia in particular having its own identity and having its own unique and independent system. And so turning now to the Parliament of the new colonies. Well, the original days of the Australian colonies, all power was vested in one person, Arthur Phillip, who came with the First Fleet and essentially acted as the representative of the British Crown to make and change all regulations and ordinances and sort of delegated laws for the new colonies. Because, again, when we're looking at that idea of sovereignty and legitimacy coming from the British Crown, there really was no separate notion or concept of this place being something sort of unique and different. And so really it's the taking of British legal authority and needing to adapt it in very minor ways in the early stages. So it wasn't until 1824 that New South Wales had the first legislature, the ability to actually make and pass laws and ordinances. Now, this was a five-member sort of advisory council, and you've got to think about the historical context here. These were penal colonies. There was there's no real concept of what we have, things like separation of powers and sort of intrinsic rights of people to demand certain things of their lawmakers, for example, the ability to choose them. But it is important to note at this stage or this step there is recognition from the British Parliament, the supreme authority, that the local government and people need to have more control. And so again, it's that slow separation from the sort of mother Britain to create this separate entity that we would now call Australia. Now, in 1842 and 1850, again, the Imperial Parliament passed the Australian Constitution Acts. These both created the state of, the colony of Victoria, and allowed for the creation of the colony of Queensland. They also changed the way the Legislative Council of New South Wales worked, and gave the individual colonies the power to alter their own constitutions and structure them in their own ways. Now, originally in all these places, they allowed for what's known as bicameral legislatures, where the particular colony would have both a lower and an upper house. And this has remained, by the way, in all of the states bar Queensland to this day. Now, each of the then colonies also were given the power to create their own constitutional documents. Now, we know, and have discussed in length even to this stage of the subject, that the federal government has a constitution, which is the Federal Compact, but each of the states also has its own constitution. And there's a very important phrase that is used in all of the constitutional documents, and that is that the states, or back then the colonies, were granted the power to make laws for the peace, order and good government of their region, geographical region, and of the citizens of that region. And I think it's a useful phrase to remember. It crops up a lot throughout your structured legal education and in practice in terms of then the colonies, but now the state governments, really justifying any particular law, particularly those laws which are contentious in terms of the removal of rights and freedoms in some ways of citizens. And that fundamentally the Constitution gives the state governments, and back then the colonies, the power to do this because of this idea that the legislatures needed to have the power to make laws for peace, order and good governance. So the court system as well also had to change with the times. Now, the very, very first court in Australia was actually established prior to the first fleet arriving, and essentially the Imperial Parliament just passed a law saying there will be a court, but essentially that court would run really by military procedure. When you've got a colony which is essentially a penal colony where all of the people there are criminals, really the structures and procedural rules of the military was really most appropriate in terms of managing that. And so, again, very, very harsh in its application. No systems of review or appeal in any way, shape or form. But again, the environment changed. So over time, what happened in Australia is that there were more and more people were freed. Convicts actually became freed people. Either their time was spent or their convictions were sometimes overturned or they were exonerated in some way. And so that sort of growing number of trend of people, essentially free citizens of the British Empire, meant that the court system had to change. And so, for example, jury trials, until the UK Parliament passed the 1928 legislation, there were no jury trials at all in Australia. And it's important to note that at this juncture, that the court structures and systems, even though they were run locally, the underlying power and rules still very much flowed from the UK. And another thing to note is that is really the evolution and change aspect of it, and that the court system is not this monolithic structure that's put into place and is intended to be that way to the sort of the end of time. Courts and how they've been structured and the histories of them throughout the colonies and later the states and also later in the federal system, they adapted and changed with the times, and things were added and removed. So some examples in recent times are the creation of things like the federal court. The federal court's only a relatively recent phenomenon. Similarly, the family court and the federal circuit courts, the district courts in the state of Queensland, and also the more specialised courts and tribunals, the planning and environment courts, the courts of arbitration. These are all things that that came later in the system, really to sort of move with the times. And so one of the themes that I've been mentioning throughout this recording is this idea that power, fundamental sovereign power, is still vested in the United Kingdom and the Imperial Parliament to make laws for the new colonies of New South Wales, Van Diemen's Land, and then later Victoria and Queensland. And this doctrine, we call this the doctrine of paramount force. That means that the sovereignty of Britain is paramount, and anything the British Parliament wants to do will simply override or trump any delegated powers given to any of the colonies. And the British Parliament did continue to make laws, and in fact this idea of paramountcy is really tied up with the idea that when the British Parliament passes a law, it's implied that the laws of Britain passed through their houses of in Westminster were intended to apply to all of the colonies of the British Empire. And at the same time, the local legislatures would also make laws that were obviously intended to bind and to operate for that particular colony. There is another doctrine in terms of trying to determine the underlying validity of that the courts sort of wrangled with throughout this period, the 1800s and the early 1900s, that idea that where a local law is somehow inconsistent with a particular British law that was expressly or intended to apply to that particular colony, then the Imperial Parliament would win. It's this idea of things could not be repugnant to the I guess the higher power, which was the UK Parliament. And this was made very clear in the Colonial Laws Validity Act in the UK Parliament in 1868, that look, all the colonies are allowed to make their own laws, but those laws have to be in agreement, in broad terms, with British law. Now, this idea of this doctrine of repugnancy, it was largely repealed in that the by convention after around the late 1800s, early 20th century, that the UK Parliament wouldn't directly create laws for specific colonies unless those colonies asked or petitioned the UK Parliament to do so. But it wasn't until a UK Parliament statute called the Statute of Westminster where this idea of the doctrine of repugnancy was formally removed. Now, curiously, in Australia as a federation, the Statute of Westminster was actually targeted or intended at the federal parliament. So the federal parliament from 1931 was no longer subordinate to Britain, in that the British Parliament just said, look, we're not going to make laws. You are sovereign in your own right. However, ostensibly at least, the states at that stage, after the 1931 statute, in theory was still this doctrine of repugnancy in theory still applied to them. And this was actually quite tricky in terms of the Australian legal system because of the process of appeal, in that for the first half of the 20th century, while appeals could be heard in the High Court, the Privy Council was higher. It was still the highest court in the land. You could go to the British, a subset of the House of Lords, and petition them to hear your matter heard, and that was higher than the High Court. And so this process of trying to limit the ability of appeals from Australian courts to the Privy Council has actually quite a reasonably complex and messy history, starting in 1968, where the federal parliament passed a law saying that you could no longer appeal federal matters from the High Court to the Privy Council, and then again in 1975, where you could no longer appeal state matters that were in the High Court to the Privy Council. But, as you can probably see, that left the problem of that you could, in theory, appeal directly from the state courts to the Privy Council. And it really wasn't until the final step was taken in the Australian Acts, whereby all appeals to the Privy Council ceased. Now, 1986 and these Australia Acts really is the final step in true Australian independence from the UK. Now, this required a series of legislation passed by both parliaments, and basically those laws say, look, we won't make laws for you and you won't make laws for us. And they both passed those legislation through each of their own parliaments, and from that point Australian courts and parliaments are no longer subject to any superior system of law or governance. In essence, Australia at that point in 1986 has completely cut the umbilical cord, and that ties from Mother Britain cease to exist. So I'm going to backtrack a bit and talk in depth about Australian federalism. Now, in the mid to late 1800s, there'd been some moves amongst the various colonies in what we now call Australia to form some form of strategic alliance. And while each colony at this stage had reached a point where there was a recognition of the uniqueness and the difference between them, was still the idea that, look, at the end of the day, we're all citizens of Her Majesty's Empire, and that what fundamentally we should be doing is to come together in order to form some form of defence. That was primarily the major goal of this, to be resilient and have a robust defence force that was more capable than each of the militia of the various 6 colonies. Now, as well as this, I guess, this higher level theme of needing to defend the realm, there were a lot of difficulties in terms of trade. And so another important aspect of Australian federalism that was discussed in a series of conventions in the last decade of the 1800s was to try and create something of a single market, in that the colonies come together not just as a military power, but also to form, I guess, one form of trading bloc, and thus reduce the internal barriers of trade and the problematic things that came from that. For example, the difference in railway gauges between the various colonies was extremely problematic at the times. Was also to reduce all of the tariffs that the various colonies would have vis-a-vis each other. Now, it wasn't in terms of what we would think in the 21st century to create to set Australia up as a region to be some form of free trade vis-a-vis the rest of the world. No, that wasn't it at all. The idea was, though, to have Australia internally to have free trade, but still have barriers and the ability to create tariffs to the outside world. And so there were a series of conventions that met starting in 1891 between the various colonies in the Australian mainland, plus Tasmania, plus New Zealand as well. And they talked again about what was important to each of the colonies, and they drafted the original constitution. Now, none of the colonial parliaments actually ratified this original draft, but it certainly did sort of sow those seeds towards that idea that, look, this is something that needs to be done. And so 7 or 8 years later, there were delegates were sent to the second lot of constitutions. Now, by this stage, New Zealand didn't really care. It wasn't really, it really wasn't interested in joining with the other Australian colonies, so it didn't send a representative. But the other colonies were were keen to thrash out these ideas, and so that there are a series of constitutional debates, and they are actually quite important as documents, as some form of source of legal history in Australia, because it really those debates really exemplify what were the needs and desires of the various colonies at the time. Largely, again, primarily fear of invasion is the single biggest driver of coming together and forming this single nation, this federal government. But it wasn't all one way. Certainly there was a great underlying trend and worry and fear that creating a central government would, of course, reduce the powers of each of the individual colonies. And so a lot of mechanisms were put in place to sort of allay those fears. And certainly in the first 20 or so years of the operation of the federal government, by and large, they didn't really do very much. And that, I guess, lived up to the expectation of those, what I suppose we refer to as the founding fathers of the Australian Constitution, that it was really a system to just make things a little bit more orderly, a bit more regular, so we could benefit from having, an internal free trade arrangement, but still tariffs against the rest of the world, and to be able to streamline and to have a single unit or defence force, and also a few other things, to be able to regulate, as I said, the railways, the telecommunication network, banking, and the currency. And so, while the various players in the constitutional conventions were debating about this, really they were trying to create a constitution that really just acts as what we call a federal compact. What they did have was the benefit of the American experience in terms of their federal system, and that had been created over 100 years before, and so that they really had the benefit of being able to look at this, examine it, and to say, well, some of these things really work, and well, some of these things really don't. And so you'll note, and it's a very important consideration when looking at the Australian Constitution, that it's really a federal compact. It's a document that enshrines the rights and powers of each of the arms of government. Now, what it doesn't do is to state overtly what the states can do. It's saying what the federal government can do, and leave silent what the states can do. And it's also silent, largely, on the idea of having individual rights of citizens. Now, we sort of look at the US and the problems that can arise, the legal problems with having enshrined constitutional rights, and the Australian teams that were sent to these constitutional debates were very much aware of this, even all the way back then. And so that was something that was, I guess there was robust agreement that the Australian tradition, in terms of protecting rights, that really that was something that was done by the Westminster system and the courts system that we already had. And so what the Australian system is doing, and when they were talking about in these debates, is to create a federal compact and overlay that with the existing governance model in the Westminster system, in that the courts of common law still actively protect the rights of citizens, and that the Parliament is, thanks to a series of constitutional documents such as the Bill of Rights, the Magna Carta, and so on, the Parliament still, while we have this notion of parliamentary supremacy, there are still certain processes that must be done, and some of those processes are the voting system, and that our Parliament is elected. And so we've got these systems of governance, these checks and balances, and really that was to be overlaid with the incoming federal structure, in terms of having this federal relationship between then the colonies and afterwards the states, and the new federal government and court system. And really that's an expression of creating this quite unique system that really represents this new idea of governance, and governance in a unique Australian way. And in trying to determine what exactly is the governance model that's employed in Western societies, it really can be helpful to think of the democratic tradition. One of the very unique things about Western society is this idea of liberalism, and that the individual as citizen has certain unalienable rights and freedoms, and one of those is the freedom to vote. Democracy, that idea that citizens express their preference to represented individuals and also concede to them their personal sovereignty. This idea of democracy is really it's very, very central to Western political thought, and even the word itself flows back to the Greek, the idea of the ancient Greek city-states and having participation in civil society. Other characteristics are the structures of constitutions, in that people and citizens and the various arms of government are all subject to the underlying constitution of the land itself. Now, in some societies, they have such as New Zealand, they have what's known as an unwritten constitution. There is no specific document that you point at and say, this is New Zealand's constitution. In Australia there is, but we still call the process of identifying what the underlying, or Hans Kelsen referred to as the Grundnorms, the great themes of our particular system. And sometimes they're expressed in this document, sometimes they're not. But the important thing is they form, the ultimate source of law. And certainly in Australia, it's accepted that the Constitution itself will trump all other areas of law. Parliament can't pass laws inconsistent with it. The courts can't make judgments that are inconsistent with our Constitution. And most importantly, people recognise this. It has power in itself, that people recognise it as the binding authority to the various arms of government. Now, another important characteristic is the idea of the separation of powers, in that we have three arms of government: the executive, the legislature, and the judiciary, and each is vested with powers to do certain things, and not vested with powers in the domains of the other two. The Parliament is vested with the power to make laws, to modify them through the process of repeal and amendment, and to re-examine them over time. The Parliament is given that power directly by the people. Elected representatives for a term are given powers to make laws. Now, Parliament, though, doesn't actually do the application step, in other words, the interpreting of the underlying law to determine rights of individual citizens. But that's left to the courts. It also doesn't execute the powers given to particular entities under the law. That's given to the executive. Parliament makes the laws and reflects upon them and changes them, sometimes repeals them, but it doesn't apply them, and it doesn't do anything. It doesn't execute them. The courts, in contrast, they do the application. They read what Parliament's done and use their own repository of law, the common law, the unwritten law, in order to determine the rights of citizens for particular cases that come before them. In our court system, judges don't get off their seats, go out into society, look at things, and make law. That's not how our system works. The idea is that courts aren't in a position to make investigations into what's working and what's not working. They can only rely on evidence and argument that's placed before them in order to determine who wins and who loses in matters that come before them to trial. And the courts internally are accountable to themselves through the system of appeal. This doctrine of precedent, this doctrine of what we call stare decisis, is the notion that a decision with the same or similar facts in a superior court will bind all subsequent decision makers in a lower court on that hierarchy. So, for example, a decision with a certain set of facts that's made in the Queensland Court of Appeal will bind all inferior courts in Queensland, that being the Magistrate Court, the District Court and Supreme Court of Queensland. It will not bind courts in other parts of the hierarchy, for example, the District Court of New South Wales. And it won't bind courts of the same or higher standing in the same hierarchy. Again, a Queensland Court of Appeal decision will not bind the Queensland Court of Appeal if a similar case comes up against it with the same set of facts or similar sets of facts at a later stage. And the High Court, as what's known as the Court of Common Apex, the top of the pyramid in our courts system, is never bound by decisions of any other court, including earlier decisions of the High Court itself. And so really, that's how we express the courts as a particular arm of government that apply the law. They don't make it, they don't have powers to investigate it, and they don't apply it. They don't get off, the judges don't get off out of their seats to perform any task to actually go about doing particular things. That's left to the executive arm of government. And the executive arm of government, they're the doers. They're the ones that have vested discretionary powers under legislation and sometimes given or granted powers by the courts in the forms of things such as injunctions. They are given powers to do things, to regulate society, to arrest people, to create ministries, to enter into treaties, and to do things in terms of other international obligations such as declaring of war. And the executive arm of government is given power through statutes. So in other words, the legislature will pass statutes. If those are validly passed, signed off by the governor in the states or the governor general in the federal parliament, they are then given power to do certain things. But they are not given unlimited power. Often statutes will give members of the executive discretionary power to make decisions in certain areas. And where those decision makers exceed that power, they go out and do things beyond what powers are given to them by the particular statute, vesting them that power, then these decisions are actually reviewable in the courts. In other words, a citizen withstanding, and again it's a complex area of law, can actually seek to ask the courts to change the decision made by the executive arm of government, or to make them make a decision where they haven't made one, or to make them not do something, or to undo a particular decision that they have made. And so it's a very important consideration, this concept of what we call judicial review and merits review in our system. That is, that the executive arm of government, given power by Parliament through a series of statutes to do and make discretionary decisions, doesn't have unfettered discretion to do what they like. Their powers, in some ways, are limited by the systems of review that we give to the courts. And it's a very important consideration for those seeking to go into the legal profession to know and understand how those three arms of government work and how they interact with each other. Now, the final characteristic of Western governance that I'm going to talk about is this idea of the rule of law. Now, in the very simplest sense, it's the idea that each is accountable to law. And that's, when I say each, I mean each citizen and each part of government. So that the courts are accountable to law. No person in that system, or in fact no person in the land, is above the law. And most importantly, this includes the executive arm of government. that no person is vested with universal and absolute power to do what she or he desires. And I think as a broad statement, that's very helpful and very, very easy to remember and to internalize. But in terms of trying to work out what that actually means, that's that idea of accountability, that both the citizen and the various arms and actors in government are accountable to the mechanics and systems of law and the underlying processes and the other institutions. And so some things that flow from that are things like the presumption of innocence in criminal trials, the idea of a fair trial, and having the ability, for example, to adduce evidence yourself and to be able to come before the courts themselves to adduce that evidence. Having the right to silence, that idea that a person can't be compelled to give evidence. And also in other areas of government, that idea that we need to have some sort of freedom of speech in order to have meaningful political communication. Citizens need to have access to justice and to representation in order to meaningfully engage and be involved with the legal system. The law is complex, and the average citizen doesn't have the structured legal education that those that practice and do it every day do. It's also very important that both the judiciary and the underlying legal profession itself remains free of political influence. And that idea that in some societies where we see this isn't the case. For example, recently in China, there have been a series of crackdowns on lawyers who have been acting on behalf of dissidents, and those lawyers themselves being sentenced to imprisonment sentences of up to sort of 7 years, ostensibly for usurping or somehow acting against the interests of the state, subverting state power, which in the very literal sense would be what maybe what was happening, but in Western society, in Western systems of governance, the need to give lawyers and the legal profession certain privileges in order to freely give advice to citizens, even those who may be doing things such as subverting state power, is something that we hold more important than making sure that people trying to subvert state power are somehow convicted and imprisoned and removed from our society. That's more important to us, having that independent systems of legal privilege and being able to have legal practitioners able to operate without fear of recrimination is more important than the underlying, the acts of treason and the terrible things that their clients may or may not have committed. It's important to note at this stage that when we're referring to the separation of powers and having each of the three arms of government independent from each other, we're not talking about the relationship between the states and local government and the states and the federal government. We're talking about, in the general sense, the legislature, the judiciary, and the executive. And the separation of powers doctrine is really designed to facilitate and maintain the rule of law in our system. It's a system of governance whereby power isn't concentrated in the hands of one person. In other words, each of the arms is not vested with the power to make and execute all areas of law. Now, the separation of power exists in each of the states and territories as well as in the federal government itself. And the federal constitution essentially acts as a compact that really explains how both the separation of powers works at the federal level as well as what the relationship is between the states and the federal government itself. It's really a system of governance that operates vertically as well as explaining, at least at the federal level, how the three arms of government, the parliament, the courts, and the executive arm of government are to operate. And so, as I mentioned earlier, there were a series of constitution conventions in the late 1800s, and at the end of this, it was narrowly voted that there shall be an Australian Federation, and so that the various colonies at the time petitioned the Imperial Parliament to create a piece of legislation there to allow for the creation of the Australian Commonwealth, to essentially give power to the Australian Constitution itself. And this is very important, what it doesn't do is to dictate any functional changes to the colonies themselves, so that each of the states and then later territories were to still retain and maintain their own parliament, court system and executive arm of government. And in each of those states that they have a constitutional document which enshrines and explains that, very similar to what the federal government has in terms of its separation of powers sections. Now, Queensland is unusual amongst the states and territories, the only one that has foregone the upper house. So Queensland has no upper house or senate. It only has the lower house, and it's something that certainly a lot of academic commentators have made the particular point that Queensland, as a result, has had a bit of a reputation for long-standing, almost tyrannical governments. Certainly the Joh Bjelke-Petersen era, where without any additional sorts of checks and balances was really able to go about making very sweeping legislative changes, and provided that essentially 51% of the voting public were sufficiently happy to vote for them, they maintained this for term after term after term. So there have been some calls, and they pop up from time to time, to reinstate the upper house, because the purpose of having an upper house is to have a place where legislation can be reviewed. Usually upper houses in most parliamentary systems don't make sweeping changes to laws. Usually laws come in through the lower house, and the upper house acts as a house of review, and they just choose to debate, talk about things, and either accept or reject that particular legislation. But Queensland, since the 1920s, has not had that aspect. And again, some commenters say that perhaps governance in Queensland is somehow diminished as a result. So I want to turn now to the relationship between the Commonwealth and the states themselves. This is a complex area of law. For those that continue down the path of becoming a legal practitioner, you'll engage with this a lot more when studying constitutional law. But it really comes from this idea that the states and the federal government have, I guess, different roles in terms of their law-making powers. And at the time of federation, when going through these constitutional debates, it wasn't really thought that the federal government was going to have a very large say in, I guess, the day-to-day operation of how each of the states runs, and I guess the lives of the citizen. So it's important to note that the federal government is given powers under Section 51 of the Constitution to do certain things: defence, telecommunication, external affairs, banking, marriage, and so on. And again, I think it's an important consideration that anything that the federal government isn't given an express power to do or to legislate over remains the domain of the states. I think that's a really important consideration, because when faced with an area of law that perhaps a citizen or a practitioner is coming across for the first time, the starting point is to try and think, well, is this something that the federal government is given power through Section 1 of the Constitution to legislate over? If it's not, it's state law. So everything by default is state law. And when we think about the sort of basic legal areas of the substantive areas that one learns as part of a law degree, we think about contract, tort, criminal law. These are all state areas of law. And when we talk about particularly cases that derive from English and from British cases, that forms part of the common law. Really, that's meaning the common law of the various states and territories, rather than being strictly federal law that flows down to the states. The states still remain powerful in that sense. So where things are problematic, though, is Section 109. Now, the Constitution's Section 109 is really designed to resolve inconsistencies between a particular state law and a particular federal law. Now, in theory, if you take what I've just previously said, but the states and the federal government legislate over quite different areas. And in theory, yes, that's correct, but in practice, things overlap very heavily. For example, the federal government is given the power to legislate over corporations, whereas the states are given, have the residual power to regulate and legislate over contract law. So, where could this be a problem? Well, what if it's a corporation involved with making or breaking a contract? Which arm of government, which of the two bodies of law is going to win? Which is going to win out in the situation? And so here, Section 109 makes it clear, if there is an inconsistency between federal and state law, the Commonwealth law is going to prevail. But importantly, it will prevail only to the extent of the inconsistency. In other words, Section 109 doesn't give the High Court the power to overturn state laws. All it does is act as an interpretive tool to say, look, where there is a clash between these things, what's written in federal statute is going to override the state law. Now, it seems quite straightforward for someone learning in the 21st century Australian legal history and legal institutions and processes. But when we go back again to these constitution debates in the late 1800s, and this particular section was put in there, and yet, as you may have heard me mention earlier, there wasn't really the thought that the federal government would become all-powerful and all-encompassing, and the states, or then the power of the colonies, which would become the states, would diminish to the extent that they have. It's really something that's happened over time. And if I were to pick a series of cases where the relative power of the states has been diminished and the power of the federal governments has increased dramatically, I think these four, well, strictly speaking it's five, but the two of them operate essentially together. These five cases, which again students of law will study in far more depth in the sort of third and fourth year elective subjects, but for now I'm just going to talk briefly about these and what they mean in terms of the diminishing of state power over the last 120 odd years. Now, I mentioned earlier that for the first 20 years or so of the existence of federation, so after the turn of the 20th century, the federal government really didn't do very much. Day-to-day living and life and lawmaking pretty well went on the same way it always had in the States. And it really wasn't until 1920, the engineers case, where there was quite a profound shift in that, I guess, what had been that sort of conventional mode of thinking, both by the judiciary and the various lawmakers in the various state parliaments. And that was, and this happened in the engineers case. It was to do with industrial relations, and what the High Court had said in this case is that we previously, up till this point, had used a lot of sort of American style precedent and cases that had come before the American superior courts to do with their constitution. And the Australian High Court in the early days was quite happy to use those and was quite heavily influenced by that. And other things that were just taken as convention and custom, both by the High Court and lawmakers, was this idea of reserved state powers. And that, look, hey, the federal government is given in Section 51 a list of exclusive areas that it can legislate over, but everything else is exclusively reserved for the domain of the states. That's this idea of this, they were reserved state powers. And this was something that was just done by convention. Judges talked about it and they said, oh yes, we accept that to be the way that the Constitution was framed and the way it operated. And the other part of this is this idea of intergovernmental immunities, that idea that the federal government just simply doesn't have the power to really involve itself in the day-to-day runnings of each of the state governments, the governments themselves, the court systems, their House of Parliament, and particularly the executive arms in each of the states. And what the High Court said here, and it was a dramatic twist, a dramatic turn on the status quo, was to say, no, actually, that's incorrect. This idea that states have exclusive reserve powers is wrong. The federal government is going to have particular powers that are granted by it in Section 51, but there is no such thing as reserved state powers. And there's also no such thing as some form of implied intergovernmental immunity. And so this was really a turning point in Australian constitutional history, and really the starting point for the federal government, really through the High Court, starting to actively gain more power at the express loss of the states. And so during the Second World War, in order to fund the war effort, the federal government imposed income tax. Now, the states till that point had also imposed income tax, and so there was this quirky system where during the war both state and federal governments are imposing income taxes, and the federal government said, and they used their defence power, which is exclusively a federal power, said, look, in times of war we've got to do what we've got to do in order to save the nation, and one of those things is that we've got to pay for things. And so the federal government said, we are going to levy income tax and we are going to gift you, money back to you being the states. And the states, understandably, they didn't like this very much, but in times of war, again, the High Court was very quick to say, no, the state governments, the federal government can definitely do this. After the war was over, of course, like any institution that usurps or takes power from another, there's this great reluctance to give that power back. And so, since that time, the High Court actually said, well, actually, the federal government can do this, and it can have the system of grants back to the states. And really, those grants are subject to its own discretion. And so, this is both a turning point in terms of constitutional history, but also the underlying structure of the Australian state apparatus of government, because it led to this thing known as a vertical fiscal imbalance. From the time of these uniform tax cases, the federal government has all of the money. The states have had financial difficulties from that period onwards. After the income tax was taken by the federal government, the states have had a really hard time with things. And so certainly the debate in Australia in the 90s about having a GST was to be levied and structured by the federal government, but part of that was to say, look, we're going to levy this because we need to correct some real revenue problems, but we'll give all of that money back to the states. And so that was really the carrot and stick of the GST debate in the late 90s in Australia. Now, the third of these cases is what's known as the Tasmanian Dam case. Now, the Tasmanian Dam case was involved an area of forestry in Tasmania. And the Tasmanian government wanted to put in a dam. And the federal government, which, and again, some of these things come about, by the way, because of there being one party in power in the federal government and another party being in power in the states. And so in the early 80s, there was a Labor federal government, I guess a more progressive government in power in the federal parliament under Bob Hawke, but there was a very conservative Tasmanian Liberal government at the time. And so the Liberal government in Tasmania wanted to chop down the trees to allow building of a dam on the Franklin River, and it would have flooded a large region which was listed as a World Heritage Area. And so what the federal government did is that they said, no, we are going to enact legislation that prohibits destruction of this, and we're going to use the external affairs power to do that. In other words, we, the federal government, signed up to a treaty, in this case the Protection of World Heritage Areas treaties, international treaties, UN treaties, and because of that we now have law-making power under section 51 subsection 29 of the Australian Constitution. And the High Court said, yeah, that's right, actually they do. And so a lot of commentators at the time thought that was the final nail in the coffin of an effective federal system. So the state governments have no longer got any cash because the federal government's got it, and the federal government can, whenever they sign a treaty, is able to legislate on things. Now, things weren't always the way of the federal government. They have lost a series of cases as well where they tried to do similar things under similar powers in the High Court. But another important one, though, came in 2006, and that was to do with the Howard government. And again, almost a mirror opposite of the early 80s. By 2005, 2006, when trying to pass this legislation, the Howard government, a conservative Liberal government, was in, and sorry, that's capital L Liberal, as in the Liberal Party. It's not a lowercase Liberal, because a conservative Liberal is almost an oxymoron. But a centre-right capital L Liberal Party was in power under former Prime Minister John Howard at the time, and that government wanted to pass wide-reaching and wide-sweeping industrial relations legislation to allow companies and individuals to have individual contracts, so that essentially bypass a lot of the industrial relations systems. Now, at that stage, the states were all Labor, so they were all, and that's again capital L Labor, very much who sourced a lot of their sort of their votes and come from the working class, those people who form unions, and that's traditionally been where the power base of the Labor Party came from. And so you've got this clash where you've got one party rules the federal parliament and the other party rules the states, and so this went to the High Court, and again the federal government won. And there they said, well, the federal government is using its corporations power under section 51 subsection 20 of the Constitution in order to create and craft this legislation. And so the High Court said essentially, yeah, that's okay. And so again, commentators again jumped up and said, oh, this really is the end. But that isn't strictly speaking the case. The states still carry on, they still exist, and they still have legitimacy and authority over their various regions, even if there is this trend towards allowing the federal government, often because the federal government has more cash, they let the Commonwealth government legislate on certain things. Now, interestingly, and again, this may be just the result of some sort of almost coercion, in that the federal government has lots of money and the state governments don't, is that from time to time the states will come together and use what's known as the referral power, which is section 51 of the Constitution, subsection 37. And that's basically a power of the federal government where the states can actually refer matters to the Commonwealth for them to legislate. Sometimes, particularly where things are difficult to maintain amongst the states, or they're expensive. In other words, that the states were just losing money hand over fist in terms of regulating certain areas. Those areas have been voluntarily referred to the federal Parliament in order to legislate over. So examples for that in recent times are things like the Australian consumer law. There, each of the states had or used to have fair trading acts, and it was a bit of a dog's breakfast because the federal government passed a piece of legislation called the Trade Practices Act in the 70s, and it meant that as a result, when you bought goods or services, you were operating under a different area of law depending on whether you were purchasing from a corporation or from a person who was a sole trader or a business partnership. And so that's extremely problematic, because usually when you go to buy something, particularly from a small business, sometimes it's impossible to tell. But the net result was, of course, you were getting quite different consumer guarantees, and those guarantees would vary dramatically throughout the states. And each of the states was having to spend money to have their large department of fair trading or something similar to manage those. And so the net result was all of the states came together, referred their powers to the federal government, and said, look, you guys legislate this, and we'll make the law that you make a law of each of the states. And so each of the Fair Trading Acts now says the 2010 Commonwealth statute, which was the Trade Practices Act renamed as the Competition and Consumer Act of 2010, and the Australian consumer law form part of the laws of each of the states. And that happened all because the states came together and used the referral power to let the federal parliament do its thing. And I think that's an important story to remember, because it's an example of what we can now refer to as cooperative federalism. In that case, the states actually all came together and ceded their power to the federal government to just try and make things easier for the citizens of the entire nation. And that essentially is it's almost an embodiment of what the Constitution was originally designed to be. It was really designed as a vessel in order to facilitate cooperation between the then colonies. And it's just unfortunate, and possibly some form of human nature, that over the last 116, 15, 17 years, that largely the states have been fighting for power, fighting for resources amongst each other. But it's nice to know from time to time that the original notion of cooperative federalism can actually work.